Welcome to another of the podcast series sponsored by the Historical Society of the New York Courts. I'm Helen Freedman, editor of the Society's publication Judicial Notice that features legal history in New York. I'm also a retired New York State Appellate Court judge, now at JAMS. We are going back 148 years to the election of 1876, the most disputed election in U.S. history. We are particularly fortunate to have with us three wonderful experts on the subject. Roy Morris, Jr. is a writer, historian who lives in Chattanooga, Tennessee. He is the author of 9 books on American history and literature, including his book, The Fraud of the Century, Rutherford B. Hayes, Samuel Tilden, and the Stolen Election of 1876. Professor Manisha Sinha is the Draper Chair in American History at the University of Connecticut and the president of the Society for Historians of the Early American Republic. She is the author and editor of numerous books and articles. Her latest book, The Rise and Fall of the Second American Republic, 1860 to 1920, was published this year by Liverite, a subsidiary of Norton, and reviewed by the Wall Street Journal, the New York Times, the New Republic, and the Times Literary Supplement, among other newspapers and journals. Third, we have Jerry Goldfeder, who is a prominent New York election lawyer and senior counsel at the law firm of Cozen and O'Connor. He's also written about the 1876 election, but from a constitutional standpoint. He is the director of the Fordham Law School Voting Rights and Democracy Project. He's also the author of Goldfeder's Modern Election Law, which is in its 7th printing. The 1876 election took place during the country's centennial year, a much celebrated event. It was also just 11 years after the Civil War, which so both divided and damaged the country. It was toward the end of Reconstruction, which historians now praise for its many positive accomplishments, but which continued to divide the country. The Republican Party had dominated the country since 1860 for 16 years, although 2 years before, in 1874, Democrats won a majority in the House of Representatives. Ulysses Grant had been president for 8 years. While he was an ardent proponent of Reconstruction and had sent federal troops and military personnel into the southern states to control their governments and ensure Black franchise and social integration of the newly freed people, his administration had become rife with corruption. A depression, the Panic of 1873, occurred, causing economic hardship throughout the country, and the country was also divided on currency issues. The 2 presidential candidates were Rutherford B. Hayes of Ohio and Samuel J. Tilden of New York. Hayes won the Republican nomination on the 7th ballot in Cincinnati as a compromise candidate. James G. Blaine had been the favored candidate. Samuel Tilden of New York won the Democratic nomination on the 2nd ballot in St. Louis, based on his national reputation as a reformer. Hayes was a 3-term, in those years, 6-year governor of Ohio. He was a former congressman, a graduate of Kenyon College who had studied law at Harvard, and a successful Cincinnati lawyer. He had been an abolitionist, had served in the Civil War, rising to the rank of brevet general, and had a reputation for honesty and fairness. He was a warm and genial fellow. Tilden was a 1-term governor of New York. He had acquired a national reputation as a reformer, having successfully challenged and destroyed the Tweed Ring, the most corrupt enterprise in the history of New York. He was also a brilliant and hugely successful lawyer and investor, having graduated in the first class of NYU Law School. And he was the founder of the New York City Bar Association, the first bar association in the country. And the first act of that bar association was to rid the city of its four most corrupt judges. He was also a lifelong Democrat, part of the liberal barn burner left-wing faction of the New York Party in New York, which had opposed any extension of slavery in the United States and favored workers' rights. He was a bachelor, and he was not a warm and genial fellow. Interestingly, both candidates favored civil service reform and what was known as hard money or specie, favored by Northern industrialists, but not by Southerners and Western farmers who favored the greenbacks. Although the 14th and 15th Amendments to the Constitution should have guaranteed Black males the right to vote, it took until 1965 for that to really happen. On election night, November 7th, 1876, almost everyone thought Samuel Tilden would be the next president of the United States. He had won the popular vote by a 265,000 margin out of 8 million votes cast, and had also clearly won 184 of the needed 185 electoral votes to win. 19 electoral votes were disputed, but all Tilden needed was one more. But what happened? Mr. Morris, can you tell us about that election and tell us what happened?
I'll do my best. As you said in your introduction, the 1876 election was supposed to be the crowning moment of the year-long centennial celebration. There was actually a record 82% turnout of all registered voters, which of course at that time meant all men, because women were not get the right to vote for another 43 years. It was also the first truly competitive two-party election since 1856, when James Buchanan, the Democrat, had defeated John C. Fremont and won the presidency. It was also the last time a Democrat had been in the White House. The 1876 election was also the first time since the Civil War that the 11 former Confederate states were all allowed to participate in the presidential election, having gone through the Reconstruction process. 3 of the states, Florida, South Carolina, and Louisiana, were still under federal occupation pending the outcome of this year's election. There was also a brand new state in this election. Colorado had just been admitted to the Union in August of 1876. Democrats in the House could have easily blocked the admission of Colorado until after the election if they had cared to, but nobody really thought that the 3 electoral votes in Colorado would have much bearing on the election. It would turn out that that was not the case. The campaign between Rutherford B. Hayes and Samuel Tilden was comparatively mild as elections went during that period. The Democrats hammered away at the Grant administration's corruption, the lingering effects of the Great Depression of 1873, called for more reform of government, civil service reform particularly. The Republicans didn't have a lot to defend, so they fell back on the tried and true tactic known as waving the bloody shirt, in which they appealed to Union veterans to, quote, vote as you shot, and reminded them that that while not every Democrat was a rebel, every rebel was a Democrat. So the election carried through, and on election night, Judge Freedman said, both candidates went to bed feeling that Tilden had won the election. He had not only carried his home state of New York, which had the most electoral votes, he had also carried New Jersey, Connecticut, Delaware, and Indiana, which was usually a Republican stronghold. He had flipped 14 states from the Republican column to the Democratic column since 1872. He'd won every border state. He had the equivalent of 1.3 million vote lead in the popular vote, and had, as Judge Freedman said, had 184 sure electoral votes. He needed just one more. The question was that the three southern states which were still undergoing the last parts of Reconstruction, Florida, Louisiana, and South Carolina, had exactly 19 electoral votes between them, which, if Hayes won all three of those states, would have meant that he won the election 185 to 184 electoral votes. It slowly dawned on Republican campaigners that night and the next day or two that, hey, they could still win the election as long as the Republicans held those three states, which had Republican governors at the time, although all three had lost or were in the process of losing re-election. Telegrams were sent to all those governors to hold on to your state no matter what, and help will be coming. Republican and Democratic campaign professionals rushed down to these three states. They call themselves visiting statesmen, which is a nice term, I guess, for it. But they really brought several of them brought carpet bags full of money to dispense to anyone that might be useful during the count. Now, the question was that what they call the canvassing boards or the returning boards in these three states had to officially certify the election for it to count. All three of these boards were controlled by Republicans, and so they started looking in. Everybody was waiting while they looked into the returns. The margins were pretty slight. Within 100 votes, Tilden and Hayes were within 100 votes in Florida, 900 votes in South Carolina. But in Louisiana, Tilden had a lead of between 6,300 and 9,000 votes. They went through the count, and the election boards in all three states, unsurprisingly, threw out enough votes for Tilden that Hayes was awarded the votes in those three states. As I said, the margin's very, very close in Florida and South Carolina, but they threw out in Louisiana, which had actually the most corrupt returning board you can imagine. They threw out 13,000 votes for Tilden under pretty flimsy circumstances. And another 8,000 potential Democratic voters in New Orleans were eliminated, were thrown off the rolls a week before the election in another very shady maneuver. The three Republican governors in these disputed southern states signed official returns awarding their states to Rutherford B. Hayes. Now, the Democrats in these three states, the newly, or I guess you'd call them governors-elect, or the attorney general in one case, signed competing returns giving their states to Samuel Tilden. The two sets of competing returns were sent to Washington, where, as we kind of remember in 2020, there was a debate on who should open them or when they should be opened, and who should decide which of these returns to approve. The vice president had died in office, and so the Republicans said that the Senate Majority Leader, Michigan Senator Thomas Ferry, who's President pro tem of the Senate, should open the ballots and decide which ones to choose. The Democrats, who had won control of the House of Representatives 2 years earlier, said that the House of Representatives should decide which ballots were the correct ones. Neither side obviously would agree to let the other do it. There was also something called the 22nd Joint Rule, which the Senate and House had passed in 1865, which allowed either one of those bodies to throw out any votes that they had a question about. The Republicans did that 5 separate times between 1865 and 1876, but they recently had withdrawn from the agreement. They called it receding from the agreement, and said that they would no longer be party to the 22nd Joint Rule. The Democrats said, well, both houses have to agree to that or you can't recede. The Republicans said, well, we just did. There was a massive stalemate. Neither side would give an inch. And so finally they came up with something called the Electoral Commission, which is probably unconstitutional. Mr. Goldfeder will know that a lot better than me, but it was supposed to be a one-time only body. It was going to be comprised.
As I recall, both candidates initially at least thought it was unconstitutional, since both were lawyers. Is that correct?
That's correct. Samuel Tilden said, well, no, the House should decide, as they had done in 1824 when there was a tie between John Quincy Adams and Andrew Jackson. Hayes said that the President of the United States had the right to appoint any federal officials, and that it was up to Ulysses S. Grant whether this commission was legal or not. Grant didn't want to have anything to do with it. They went forward despite what Hayes and Tilden believed, and they went ahead and selected a 15-member electoral commission. 5 Democrats from the House and Senate, 5 Republicans, and 5 members of the Supreme Court. 2 were Republicans, 2 were Democrats, and 1, David Davis of Illinois, was declared independent. The Democratic Party in Illinois, in a remarkably stupid thing to do, named Davis to the U.S. Senate the very day that the Electoral Commission was approved. And he immediately resigned from the commission. He probably didn't want to be on it anyway, which left them 1 short. So they picked another Supreme Court justice, Joseph Bradley, who was supposedly the most moderate of the Republicans left, although his son later said that his father was as Republican as any Republican on the commission. With the Electoral Commission set, they met on February 2nd in the Supreme Court chambers to decide who would get the votes from the 3 disputed southern states. The Democratic attorneys argued that the election boards in those 3 states had committed fraud by throwing out votes for Samuel Tilden right and left, and then had signed fraudulent returns, which the governors of those states endorsed. So they said that the Electoral Commission should go behind these returns and investigate all the shenanigans that had taken place before the returns were approved. The Republican attorneys before the Electoral Commission argued that the Constitution left the elections within each state. They left the power to the states themselves to conduct and decide who had won their state's electoral votes. So this went on for, I think, 4 days. Obviously, the 7 Democrats and 7 Republicans were going to vote with their party. So it all came down to Justice Joseph Bradley, who spent the night before his decision was to be announced. He was apparently up all night. He said he had insomnia. There was a lot of rumors that people had been visiting in and out of his home in Washington all night long, pressuring him one way or the other to decide on this vote. One of whom was supposedly one of the Republican members of the Electoral Commission, which is a tremendous conflict of interest. But there was no evidence of that. And Bradley and his family said no one had come by all night. So without any proof, it's impossible to say for sure. On February 7th, he announced his decision. What he decided, in essence, was that the Electoral Commission could not go behind any votes in any of these three states, that he based it on an 1810 Supreme Court ruling, which had said that Supreme Court would not investigate state returns. So with that decided, the Electoral Commission voted 8-7 in favor of Hayes to give him all those states, which would give him 185 electoral votes. You can imagine the Democrats went crazy, said the vote had been between 8 villains and 7 patriots. But there was really nothing they could do about it. Then we come to another very mysterious happening, which was that there was supposedly a secret meeting between Hayes supporters and Southern Democrats at the Wormley Hotel in Washington on the night of February 26th, before the final votes were taken. A historian named C. Van Woodward wrote a whole book about this, in which he claimed that Hayes, or Hayes's people, including future President James A. Garfield, had agreed that Hayes would remove all the remaining federal troops from the South in return for the Southern representatives in Congress to accept that he had been elected, and not try to filibuster, as some were talking about doing, until the Electoral Commission went out of business on March 2nd, I believe it was, or March 4th, in which case there wouldn't be a president at all, and they'd have to have a new election. Woodward called it the Compromise of 1877. No one had ever admitted that they'd been at such a meeting, and it really doesn't make a lot of sense anyway, since by then Hayes knew that he was going to win the election. All it had to do was go through the final count of South Carolina, of the final approval by the Electoral Commission, and he would have the votes. So he didn't have to agree to anything. Plus, the troops were going to come home from the South anyway, because the Democratic-led House of Representatives had refused to approve any more funds to fund them. So they had no money. So the troops were going to come home whatever Hayes did or didn't do. As far as the Democrats in the South were concerned, they had already won the governorships in those three states, and they didn't care much one way or the other whether Tilden or Hayes, Tilden being obviously a Yankee from New York. They didn't care which of them was president as long as they got local control of their states. Some Democrats still urged Samuel Tilden to go to Washington and just declare that he had been elected president. And they said they could raise a whole army to support him if he did that. Well, Tilden, who was not a stupid man, looked and was patriotic. Let's give him that. He said he wasn't going to do that he had no claim to the presidency, and that anyway, the Republicans controlled the Senate, the Supreme Court, the White House, and the Army. So there was no way that he was going to go to Washington and try to claim that he was president. So that's the way it was left. Hayes made plans to come to Washington. Tilden made plans to go on a long trip abroad. And so Hayes arrived in Washington and had dinner with Grant at the White House. One last little bit of business was that Grant's term of office ended officially on a Sunday, and the inauguration of Hayes wouldn't take place until the day after. So Grant and Hayes agreed to have Hayes secretly sworn in as president in one of the back rooms of the White House 2 days early, in case the Democrats tried anything in between that one day interregnum. So that's a long story, long wise, but that's pretty much what happened. And Hayes took the oath of office on March 5th, 1877. He was immediately a lame duck because he said he wouldn't run for re-election, which meant that the Republicans didn't listen to him. The Democrats refused to agree that he was even legitimate. They called him Rutherford B. Hayes, or his fraudulency, or old 8 to 7. So they didn't listen to anything he did. And he essentially spent 4 years in the White House not doing much of anything. The troops did come home from the South, which he had no power to stop or influence one way or the other. Meanwhile, Tilden accepted the election. I think he said that he was at peace with it. That's pretty much what he expected anyway. He said he could live with the fact that he knew himself that he had been elected president, but he didn't have any of the responsibilities or problems of being president. When he died a couple years later, or a few years later,
it was actually 1886, I think.
1886, that's right. So several years later, when he died, on his tombstone, there's a legend that says, I still trust the people." So anyway, that's kind of what happened in the election of 1876 and the post-election of 1877.
Okay, and if anyone wants to see that tombstone, it's in New Lebanon, New York, and it's very, very big and prominent, and those words are clearly on it. As a New York Historical Society, I went and enjoyed looking at it. Professor Sinha, would you like to respond? Would you like to tell us why Hayes probably should have been president?
Well, first of all, let me thank you, Judge Freedman, for hosting us today and for your introduction. And I am not going to go into the machinations of the elections of 1876. That has been told well by the previous speaker. Instead, what I'd like to do is to talk about the broader historical context to the presidential elections of 1876. Which I also call the counter-revolution of 1876, because it led to the fall of the last three Reconstruction governments in the South that were dedicated to upholding an interracial democracy and Black citizenship. So the fall of this Second American Republic, which was really created during Reconstruction with the three important constitutional amendments, 13th, 14th, and 15th Amendments, but also by federal laws, the first federal civil rights laws, the first federal agencies to aid citizens in the South, not just freed people, but also impoverished Southern whites suffering after the Civil War. All this was part of what we call the reconstruction of American democracy after the Civil War. But the presidential elections of 1876 marked an end, or at least a stepping stone towards the end. By the 1890s, the South was firmly under the control of conservative Southern whites. They called themselves the Conservative Party, in fact, in the South, and the Republicans, the Radical Party. And for your listeners who might be confused, everything you know about the two parties today, simply flip it for the 19th century. The Republican Party was the party of Lincoln, anti-slavery, racial liberalism, and big government. And the Democratic Party was the party of pro-slavery, states' rights, opposition to Reconstruction, and white supremacy. That's really important to remember, regardless of the personal political careers of Rutherford B. Hayes and Tilden. Tilden, as Judge Freedman pointed out, was a free soiler. He was a barn burner Democrat against the expansion of slavery, joined the Free Soil Coalition that nominated his mentor, Martin Van Buren, in 1848. And during the war, he had been a war Democrat. He had not been a copperhead, a peace Democrat, like Clement Vallandigham, who was basically a traitor to the Republic. So Tilden actually had these progressive credentials, but he represented a party that was unalterably opposed to the platform of Reconstruction, to the platform of Black citizenship and voting rights. And that's important to remember. He had, in fact, acted as a manager for Horatio Seymour, another governor from New York, who had contested the 1868 presidential elections against Grant. So the fall of the Second American Republic, or Reconstruction, of course, had its roots in President Grant's second term. His reelection in 1872 should have signaled, as many African Americans and radical Republicans hoped, that the federal government's commitment to Reconstruction would remain in place, or at least would not collapse. Yet his second term was marred not only by an increase in racist terrorism in the South, so the federal government is not just sending troops to the South for the fun of it. There's actually a regime of domestic political terrorism led by groups like the Ku Klux Klan, the White League in Louisiana, which was notorious, the White Liners in Mississippi, and the Red Shirts in South Carolina. These were domestic political terror groups, and to even argue that any returns from the South that was dependent on voter intimidation and violent intimidation of Black men voters, and many times white Republicans as well. White Republican office holders were often killed. A congressman from Arkansas was actually assassinated by these groups. So to argue that any of the returns from the South represented any semblance of a democratic process is a bit of a travesty. And that is true also for the 1876 elections in Louisiana, South Carolina, and Florida, the three states which sent back these contested returns during the presidential election. So the federal retreat from Reconstruction, of course, would be epitomized not just by domestic terrorism, but also by a series of Supreme Court decisions that vitiated Reconstruction laws, federal laws, and constitutional amendments. But if we just focus on the presidential elections of 1876, then we must understand that that campaign was a counter-revolution. Though terrorist violence had predated this moment, it had occurred all throughout the South. Throughout Reconstruction, there were sore losers, might have lost the war, would refuse to concede the peace, and in fact, eventually ended winning the peace. So this kind of violence is put into place by the Mississippi Plan of 1875 and the overthrow of these last Reconstruction state governments. What was this plan? Wholesale racist terrorism. Counties that would have thousands and thousands of Black voters would end up having only 2 or 3 Black men voting because they had actually been literally murdered into not voting. And this is, again, very important to remember. It's there in federal government archives, in all the investigations that were done in Mississippi, and Louisiana in particular was awful. In 1868, it was the one Southern Reconstructed state that actually gave Horatio Seymour its electoral votes and not Ulysses Grant because of the level of terrorism by the Knights of White Camellia, the White League, and other Klan-like groups. Republicans were murdered in cold blood, and massacres of freed people were common. So the Mississippi Way of 1875 had become pretty common. And by 1876, most of the southern states, through this campaign of terrorism, had, quote, redeemed or I would say restored, their governments to elite conservative Southern white rule. It's not until the 1890s and the rise of the populist movement that this conservative rule is challenged a little bit. And it's one of the reasons my book goes beyond this election and the so-called compromise of 1877, right up to the 1890s, when Jim Crow is put into place and Black men are systematically disfranchised in Southern state constitutions, starting with Mississippi in 1890 and continuing with all the other Southern states. So let's talk a little bit about the 1876 presidential elections, not so much in terms of those fine political maneuverings, all of which is somewhat speculative, because we don't have much of a smoking gun in terms of what exactly happened. But let's talk about it in terms of its significance for the downfall of Reconstruction, for the downfall of Black freedom in the South, which also represented the downfall of American democracy in the American Republic as a whole. So the 1876 presidential elections demonstrated how thoroughly political terror undermined the Second American Republic. In majority Black Mississippi, now restored to minority rule, a combination of violent intimidation and economic coercion of vulnerable sharecroppers and laborers handed the state to the Democratic presidential nominee, Samuel Tilden. Mississippi also elected a conservative congressional delegation. The decline in Republican votes in Black Belt counties was dramatic. Reconstruction in North Carolina ended with the election to the governorship of the man who had served as a Confederate governor in the state during the war, Zebulon Barnes, on a platform of white supremacy. In states that had overturned Reconstruction, electoral fraud was brazen. In Texas, Klan terror saw numerous Black women raped and German Unionists attacked. Those arrested for the crimes were let off by conservative white juries. In Georgia and Alabama, conservative control of state government handed the elections to Democrats. White paramilitaries from both states often crossed borders to attack Black people and their allies in Mississippi and South Carolina. Electoral violence during the elections of 1876 in Alabama and Mississippi were, quote, fit subjects of investigation, wrote one abolitionist. A Senate committee headed by George Boutwell produced a report on the violence during the 1875 Mississippi elections. It recommended the passage of more federal laws to protect voters, to deny congressional representation to states controlled by lawless armed bands, as stipulated in the 14th Amendment. In fact, a provision that has never been enforced. Many of the provisions of the 14th Amendment that seem like a dead letter to the United States Supreme Court. And if violence persisted, to remand the state back to a territorial stage. It concluded, quote, the nation cannot witness with indifference the dominion of lawlessness and anarchy in a state with their incident evils and a knowledge of the inevitable consequences. None of its recommendations was followed. Investigating electoral violence in 1876, Senator John Sherman reported on similar events in Louisiana. Quote, it seems more like the history of hell than of civilized and Christian communities. The Southern elections, the anti-slavery, the Commonwealth editorialized, was an absolute farce. In the South, quote, a Negro massacre has come to be a very small matter indeed. The shirt is bloody, very bloody, dripping with blood. And this illusion actually comes from a speech by Senator Benjamin Butler in Congress, where he could literally talk about the bloodied shirt of Republican office holders who were massacred and assassinated in the South in Mississippi, where his son-in-law, Governor Adelbert Ames, was the governor. So that's where the allusion to the bloody shirt comes. It was not just an empty political rallying cry. It actually alluded to murder and mayhem in the South, where the rule of law was a farce at this time. If the president was elected through wholesale murder, intimidation, and, quote, damnable outlawry, it would be the last throb of popular liberty in the republic. That's what the editorial said. The extent of voter suppression and terror in the South could be seen in the large majorities for Democrats in states with substantial Black populations. So the illusion that Tilden somehow won the popular vote has to be said with a complete disregard for what is happening in the South at this time. The Commonwealth noted that, quote, terrorism has added its horrors. And today, 7 states in the South that under a peaceful order of things were likely to vote for the national Republican candidate may all be placed either in the Democratic column or in the list of doubtful. Tilden won a majority of the national popular vote, an illusion resulting from the violent suppression of Black voters in southern states. With, quote, a fair and untrammeled election, most of the Deep South states would have been as Republican as those in the Northeast. The Democratic nominee had won 184 electoral college votes, though some states had not yet been decided. Tilden needed just one more electoral vote from, quote, bribery in Oregon, usurpation in South Carolina, forgery in Florida, and slaughtering in Louisiana to win the presidency. The Republican nominee, Rutherford B. needed 19 electoral college votes from the states of Louisiana, South Carolina, and Florida, which still had Reconstruction governments to win. If the Republicans had acted with firmness against racist terror, the whole country would have been behind them. But, quote, timidity had invited aggressions. And this is clear. Grant simply stopped enforcing the enforcement acts in his second term because he is on the defensive, because of the panic of 1873, because the Democrats win the House for the first time since the Civil War in 1874, because of the corruption scandals, which, by the way, were not totally the domain of Republicans. Democrats were involved in this too. Tilden himself, though, was a reformer and had been known to fight corruption. But unfortunately, he stood on a platform that was so anti-democratic and so anti-Reconstruction that his own reformist credentials get somewhat muddied since he was the head of that ticket. Now, it became clear that disputed returns from Lawrence and Edgefield counties, where the Red Shirts, the terror group, was particularly active, would decide the gubernatorial and presidential elections in South Carolina. Imported red shirts from Georgia voted fraudulently in both counties, while federal army officers reported that hundreds of Black men had been prevented from voting at all. This is all in the National Archives, and all the evidence is right there to be read. The State Board of Canvassers, as it was called, and the Republicans from the 2 counties had declared Chamberlain, who was Daniel Chamberlain, the Republican governor, and the Republicans victors. But the state Supreme Court awarded the election to Wade Hampton, a former Confederate general who rode at the head of the Red Shirts, and the Democrats. In Louisiana, as in South Carolina, conservatives had nominated a former Confederate general, Francis Nichols, for governor, a supposedly moderate cover for the White League's violent political campaign. But it was open season on Black people and Republicans in the countryside with, quote, bulldozers, as they were called, hanging 2 Black women, one of whom was pregnant, in East Feliciana Parish, and assaulting a German Republican from West Feliciana Parish. In another parish, they lynched African Americans, in one case killing a Black man, assaulting his wife, and slitting the throat of their baby, and assaulted the tax collector there, who was also a Republican. These tactics, these murders, were planned political assassinations and tactics of terror and intimidation, and no accounting of the elections of 1876, the presidential elections and the state elections, can afford to ignore them. Now, like Hampton, Nichols quickly set up a shadow state government before the official winner was declared. Florida, with a 40% Black population, gave a painfully narrow majority to the conservative gubernatorial candidate George F. Drew that was upheld by the state courts. Now, Republican-controlled state election boards in all 3 states, however, certified Hayes as victor. Their Democratic challengers responded by sending in competing returns in favor of Tilden, creating an impasse in Washington that we just have heard about. In January 1877, Congress created an electoral commission composed of congressmen from both parties and 4 Supreme Court justices to decide the victors in the 3 disputed states. In March, the commission, with a one-man Republican majority, gave Hayes the electoral votes of all 3 states and averted a Democratic filibuster in the Senate. And it must be noted that the Republicans themselves were retreating from Reconstruction at this time, and many of these Supreme Court judges had been part of some of the most deplorable Supreme Court decisions, like the Cruikshank decision that led white terrorists in Louisiana go scot-free. Later on, of course, they would extend their glory by Plessy versus Ferguson, the civil rights cases that all kneecapped Reconstruction laws and amendments. So it's not clear that simply partisan loyalties were at play here. A lot of the Republicans were liberal Republicans, conservative Republicans, like Hayes themselves, who felt that Reconstruction should be ended. Now, one observer, unable to predict January 2021, wrote that, quote, no Congress will again want to go through another session of such disorder, anxiety, and threatenings. So things were in flux in Washington. Hayes took office that same month. And after a suitable delay, as advised by Carl Schurz, who was also, quote, a liberal Republican, not liberal as we understand it today, but a classical laissez-faire liberal who felt that government should not interfere in economy and society at all, what we call political conservatives today. And most of these men were very anti-Reconstruction and against any regulation of business, of big business. They were sort of the pathway from the Reconstruction era to the Gilded Age, when the Republican Party itself became the party of big business. So Hayes ordered federal troops stationed at state houses in Louisiana and South Carolina back to camp. A common misconception is that he called them back up north. No, he just told them to go back to camp, effectively handing over the state governments to conservatives and their armed paramilitary forces. So this is what is so odd about 1876. These 3 states that declared Hayes, the Republican, as their victor at the state level and the local level gave up power to Southern Democrats. So you have this split that historians have tried to explain in various ways. The federal troops in Florida had already been withdrawn in January. Just over 3,000 federal officers and soldiers were now stationed in the South, a steep drop from 60,000 at the end of the Civil War. Most of the withdrawn soldiers were reassigned to the West to fight against indigenous nations. The standing down of federal troops in Louisiana and South Carolina at Hayes' direction formally ended Reconstruction. The dark irony of the situation was not lost on observers. As Daniel Chamberlain summarized the developments to South Carolinian Republicans, quote, today, April 10th, 1877, by order of the President, whom your votes alone rescued from overwhelming defeat, the government of the United States abandons you, deliberately withdraws from you its support, and by the withdrawal of troops now protecting the state from domestic violence, abandons the lawful government of the state to a struggle with insurrectionary forces too powerful to resist. So it was the end of the rule of law in the South. The next day, Chamberlain handed over the seal of his office to Wade Hampton. Now, a black South Carolinian remarked, quote, to think that Hayes would go back on us when we had to wade through blood to help place him where he is now. On April 25th, black Louisianans were dealt the same fate. Hayes' associates had probably struck an informal deal. He would get the presidency in exchange for conservative rule in the 3 disputed states. The unholy bargain was supposedly struck at Wormley's Hotel in Washington, which was owned by a prominent black entrepreneur, James Wormley. Wormley had been an agent for Garrison's The Liberator and a confidant of the abolitionist senator from Massachusetts, Charles Sumner. And he was, of course, a man who had his sons serve in the Union Army. Now, John Lynch, the Black Republican who lost his seat in Congress in 1876, was a popular. He said, to such a bargain, I did not care to even be an innocent party. Now, historians have speculated on the exact terms of the unwritten Wormley bargain, better known as the Compromise of 1877, or whether it even occurred. For instance, did it involve railroad interests, or did it simply concern the election of a Republican president in exchange for restoration of white supremacy in the South? Now, as was said previously, the Southern historian C. Van Woodward believed that railroads had their say. While such specific claims have been disputed, Northern business interests certainly favored the end of Reconstruction. Abolitionists at the time understood that clearly. Wendell Phillips claimed that, quote, the treacherous bargain included a provision to charter the Southern Pacific Railway, giving away millions of national acres and millions of national bonds. Hayes, as even his supporters conceded, took advice, quote, from the ruling classes in business and financial circles. Indeed, the Republican Party soon proved to be more assiduous in protecting business than freed people. And in fact, the Supreme Court in the Santa Clara case would interpret, or rather misinterpret, the Equal Protection Clause of the 14th Amendment, specifically designed for freed people to protect the interests of railroads.
Okay.
From government regulation. I'm just ending. Indeed, the Republican Party soon proved, as I said, proved to be more serious for business. By the end of the century, it had been transformed from the party of Lincoln and anti-slavery and black rights into the party of big business. A small contingent of federal troops remained in the South, and sporadic efforts to combat voter suppression continued in the 1880s, especially when Benjamin Harrison became president and the Republicans for the first time got control of both the Senate and the House of Republicans. The effort to have election law, the Lodge Bill, to have a national education system and a Department of Education, the Blair Bill, all these efforts took place then. They didn't succeed, but at least there was that waning commitment to Reconstruction that continued. But Reconstruction as a national policy came to an end in 1877 after the presidential elections, even though some Republicans continued to champion Black rights and attempted to halt the slide in the 1880s.
Okay.
In 1878, the Posse Comitatus Act severely limited the use of federal troops to restore the rule of law in the states, which was the Enforcement Acts of the 1870s. 9 years later, the Electoral Count Act of 1887 tried to prevent the submission of rival electoral votes from states, which has never happened since 1876. In 2022, however, attempts to overthrow the results of the presidential elections led to the passage of electoral reform that would prevent such illegal maneuvers. Reconstruction would be completely overthrown only with the formal rise of Jim Crow and legal disfranchisement of Black men in the South in the 1890s. The counter-revolution of 1876 did not completely end Reconstruction, even if it was an important stepping stone in its unwinding. Perhaps fittingly for a nation that sanctioned slavery in its inception, 1876 was the centennial also of the birth of the American Republic. Thanks so much for listening.
Okay, well, that was very interesting, and we can talk a little bit later, but now I'd like to have Jerry Goldfeder talk from a lawyer's point of view about the constitutionality, really, of the Electoral Commission and what happened in 1876.
Thank you very much, Helen. Thank you, Judge Freedman. And it's good to be with both of the other panelists today. There's no doubt that the 1876 election was marred by violence, voter suppression, I believe on both sides. And we have a history in our elections of the political parties and their supporters going beyond the law in order to win an election and using the laws to try to win elections. In the current period in which we're living, Laws are changed from time to time for the purpose of either winning an election or defeating an opponent. So none of that is new, except, of course, during the Civil War and after the Civil War, there was the kind of violence that was spoken about. And needless to say, the Jim Crow laws and the suppression of Blacks from voting over many, many years until, ironically, Lyndon Johnson became president, and that started to change with the Voting Rights Act. I say ironically because he was a senator, originally a senator from Texas. But all that being said, the rule of law is what I want to address. So there were these forces that supported the Democrats and supported the Republicans, and they did what they did. But nevertheless, on election day, the votes were cast and the votes were counted, because that's the way it works, irrespective of what goes behind that, irrespective of the forces that may be suppressing votes on both sides. We have the votes and we're counting them. And on election night, as has been described, it was clear that Tilden had won, but there was an effort by the Republican Party to make sure that certain states, Louisiana, South Carolina, and Florida, were sufficiently ambiguous such that it wasn't clear that Tilden won those states. Well, in fact, it was clear, as Professor Morris said, that he won Louisiana and he won South Carolina. The vote in Florida was pretty tight. It was about 80 votes difference. So it wasn't that clear in Florida, but nevertheless, it was pretty clear in Louisiana and in South Carolina. So by all accounts, he really won that election on election night. But yet, the election regulators in those three states had it in their power to determine who the winner was. That's what election regulators do. They have to count the votes and make a determination as to the official results. What we saw on election night were only the unofficial results. And once the Republican leadership determined that they could possibly win the presidential election by holding those states and even turning those states, they went to work. They sent lawyers and representatives into all three states. And as the election regulators, they're called, I'm using my cheat sheet here. In Florida, it's called the State Canvassing Board. In Louisiana, it was called the State Returning Board. And in South Carolina, it was called the Board of Canvassers. But we in New York, we call it the Board of Election. It's all the same. And pursuant to the Constitution, the states regulate federal elections. They run the elections. They decide what the eligibility requirements are for voters and what the procedures are. And they make the determinations on how to count the votes and, if necessary, recount the votes. So we have the election regulators in 1876, just like we have election regulators now, and a determination by the Republicans to try to turn those states. And as I say, both sides sent representatives there, and they questioned ballots. These ballots don't count because people didn't vote pursuant to the instructions. These ballots should have counted, voters should have been able to cast ballots, but they were prevented from voting. So there were affidavits, there were testimony, all before the election boards in order to persuade the election boards in all those three states what the results should be. And as Professor Morris said, that even though Louisiana, for example, where Tilden was initially ahead by unofficial results by between 8,000 or 9,000 votes as a result of the lawyers and the representatives arguing about which ballots should count and which ballots shouldn't count, and so on, just like we do today. The result was that they disqualified approximately 13,000 Democratic ballots and approximately 2,500 Republican votes. So the Republican-controlled election regulator in Louisiana, after this entire counting and recounting process, after listening to testimony, after getting affidavits, made a determination, well, Hayes won. And the same thing happened in Florida, and the same thing happened in South Carolina. So, pursuant to the practice, whoever won sends their electoral college vote totals to Washington. It's what we now call certificate of ascertainment. And it's like the Academy Awards. They send the envelopes with the winners to Washington, D.C., and on a appointed date, the Congress meets and counts the electoral college votes, just as we did in the beginning of the Republic and just as we do now. Well, as a result of the partisan conduct of the election regulators in all three states, the Democrats sent their own set of electors to Washington, D.C. So Congress is sitting in what would be comparable to our January 6th. The dates were different because the president's term was through March 4th instead of January 20th. So they sat, the Congress sat pursuant to the 12th Amendment to the Constitution, and they went, starting with the first state, they go through the alphabet of the states and they count the electoral college votes as has been sent to DC, just as we do today. So in 1876, we have competing electoral college votes. The House was controlled by the Democrats. The Senate was controlled by the Republicans. So there's a question. We didn't have statutory rules with regard to what procedures to follow. All we have is a contest between the Democrats and the Republicans in certain states. What to do? Well, the Republicans argued, they looked at the 12th Amendment and they said that it said the vice president shall preside over both houses of Congress and the votes shall be counted, passive voice. So the Republicans argued that the presiding officer, as Professor Morris said, there was no vice president at the time, so it was the president pro tem of the Senate. The presiding officer should determine which votes should count. Sound familiar? That was exactly the argument that was made by Donald Trump to Vice President Mike Pence. Well, the argument was rejected in 1876, just as it was rejected in 2020. And so the question was, since there were competing political forces in the House and the Senate, how to proceed. And as I said, there was no Electoral Count Act, so the procedures were ambiguous as to how to proceed. The right thing to do, the constitutional thing to do, the constitutional course at that time, in my view, was, since there were competing electoral college votes in several states and not one candidate had the majority, Tilden was one shy, since no one had a majority, it should have gone to the House of Representatives. And Democrats wanted it to go to the House of Representatives, this contingent election, again, pursuant to the Constitution, and they would have determined who the president was, each state having one vote. And since the Democrats controlled it, they should have insisted on doing it. But for a variety of reasons, political reasons, they didn't do that. And some of it had to do with the fact that there was still this aftermath a feeling, aftermath of the Civil War, there was a feeling that tensions were so high, and some of the violence that Professor Sinha spoke about was really on the minds of the Democrats and the Republicans. So in a way, they tried to, we could look at it as they punted, or we could look at it, well, let's find a solution where both sides will be agreeable to work out who the winner was. That's a generous analysis. I think what the Democrats ought to have done is insisted on the House meeting and electing the president, but they didn't do that. And so they came up with this, to use a legal phrase, they came up with this cockamamie scheme to have a commission make a determination as to which of the electoral counts from the electoral college slates from those 3 states and whatever other issues there might have been, make the commission make those determinations. Now, the Congress could have made that determination on its own, but it chose not to. Just as the Democrats chose not to insist upon the House using the contingent election provision in the 12th Amendment to the Constitution, the Congress could have made a determination by majority vote as to which electoral votes it was going to count. Sure, it would have been difficult because the House was controlled by the Democrats and the Senate was controlled by the Republicans, but they could have done that. It's not out of the realm of possibility, simply because when we've had previous presidential elections, when there was a contention as to who won, Congress has made a determination. In 1824, the House did, even though it wasn't clear who won. So it was in their power to do so. It was in the power of the Democrats to insist on a contingent election. It was in the power of the Congress to make a determination as to who won the presidency by determining which electoral votes to count, which electoral votes to count, but they determined not to. They determined to create a commission, which they would ultimately approve, the results of which they would ultimately approve. But this commission, this independent commission, which was comprised of Democrats and Republicans and supposedly one independent, would be fair and objective as to who won. And as Professor Morris went into detail about it, the commission met, and they made a determination that essentially whatever the states had decided, we, the commission, we are going to adopt, and therefore we're going to adopt the official results of the election regulators, irrespective of how partisan they were, irrespective of how corrupt they were, irrespective of how they went into it knowing that they were going to be supporting Hayes after all the lawyers did their work in those particular states. The Electoral Commission adopted the election regulators in those states' determinations and therefore handed it back to the Congress, and the Congress approved. Now, there was that, supposedly there was supposed to be an independent Supreme Court justice, and as Professor Morris said, he became a United States Senator, resigned, and so we effectively had 8 Republicans and 7 Democrats on the commission, and they, as a body, acted in a partisan way, just as the election regulators in each of the 3 states acted in a partisan way. Congress approved, Hayes takes office, and whatever kind of issues that some of the Democrats had with them, not all the Democrats cared all that much, because they all, as Judge Freedman was saying, Tilden was not a lovable guy, and so they were not crazy about putting him in office to begin with. because of the politics of Tilden were not the politics of many of the Democrats who were racist. Tilden was not. And so in order to kind of placate the Democrats so they wouldn't force a vote in the Congress with regard to the presidency, they gave in. And what they got in return is the end of Reconstruction, as Professor Sinha has laid out pretty thoroughly. So what we have, when all is said and done, is, despite the way it looks, the rule of law prevailed. The rule of law in each of those states, pursuant to the Constitution, the election regulators in each of those states counted the votes and made a determination and came to a conclusion. And they sent their electoral votes to Washington, D.C. Sure, the Democrats sent their own, but they were the election regulators. They had the governors on their side. They sent the certificates to Washington, D.C., pursuant to their constitutional authority under the laws of their state. They acted legally. And once Congress enacted the law creating the Electoral Commission, the commission made a determination that it was not going to muck around with what the states had made the states' own decisions, because once they start doing that, then you have commissions and Congress looking at election results in all the states, and that's not the system that we had in place. The system we had in place, and we still have in place, is the states make the determination. And the Electoral Commission did not go behind that, and that was in keeping with and pursuant to the authority laid out to the states by the United States Constitution. So what the Electoral Commission did may have been right or wrong. What they did was consistent with our constitutional framework. Even though the Democrats could have insisted that the constitutional framework of the House choosing the president was a way of electing the president, which should have been adopted. But once Congress made the determination, Democrats and Republicans, to bypass that, the Electoral Commission acted, Hayes took office, and that's the end of the story. So in a way, even though there was this violence, even though there was this partisanship, even though there was this corruption in the way the determinations were made, one can fairly say that irrespective of the results, they acted, the process was pursuant to the rule of law. Now, what did Tilden say about that? And I'm going to read something to you, which is what he said a few months after the election. He was talking to a civic group in Manhattan, and he said the following: "Everybody knows after the recent election, the men who were elected by the people as president and vice president were counted out." He's talking about himself. "And the men who were not elected," Hayes, "the men who were not elected were counted in and seated." And this is the interesting part. "If my voice could reach throughout our country and be heard in its remotest hamlet, I would say, be of good cheer. The Republic will live. The institutions of our fathers are not to expire in shame. The sovereignty of the people shall be rescued from this peril and reestablished." So he chose to be optimistic about the survival of our republic, irrespective of the fact that he knew that the election was stolen from him legally, and he was obviously disappointed, but he had faith, or at least he chose to speak to his faith, that the republic will survive. There will be future elections. And I've always chosen to read that particular quote to my election law students because as we see, elections are not easy. Elections are sometimes corrupt. Sometimes the winner of the popular vote loses in the electoral college and people are disappointed, but it's pursuant to the Constitution. And I try to convey the view that we need to take the long view. You know, in 2016, many people, half the country was very upset. In 2024, in 2020, the other half of the country was very upset. And in 2024, it flipped again. We need to take the long view. The most important thing is that the rule of law prevails. The most important thing is that we have laws that enable free and fair elections, and that when those free and fair elections occur, that people accept the results. That's what will enable the republic to survive. And with that, I'll turn it back over to Helen Freedman.
Well, thank you very much, Jerry. And thank you very much. All of our speakers spoke so well and so, I would say, convincingly. But that just leads me to a couple of questions, which I ask any one of you to address. I was going to say, do you think Tilden actually won the election? But I think we've heard where each of you stands on that. So my next question is going to be, who do you think would have made a better president? Or do you think Tilden would have been a better president for any reason? Is anyone willing to take that question?
Well, I just want to say that when you gave your introduction, Judge, you talked about the amiability of Hayes. He really succeeded in the state of Ohio and then became the nominee because of the kind of person he was. And Tilden was really not one of these folks who got along well with people. People respected him and so on. So
he was a very successful governor.
He was very successful in his programs and his policies, but there was respect, but there wasn't a lot of love. So on that level, a person who is able to get along with people can sometimes be a better president than someone who is sure about what his policies are and is respected, but is not necessarily someone who knows how to navigate between and among various factions and so on. So from just that point of view, that's not a political point of view in the sense of what the politics are and what the policies are, but just as people, it's sometimes better to have in office someone who can bring people together in a way that understands what leadership is about. And I just have the sense from history that Hayes was better at that than Tilden. I'd really be interested in Professor Morris's view about that.
Well, I have a piece of history to tell you about, but I won't, as moderator, say it. Go ahead, Mr. Morris. You've raised with me some points that I think are interesting.
Well, I totally agree in the sense that Hayes was a better politician than Tilden. In fact, one of the sort of the unwritten matters of history about the election is that when we got past election night, Hayes was much better at meeting with people, at directing his forces, at sort of like the Republicans are now. They're much better at a message. Now, Tilden, being a very smart and very somewhat remote man, spent his time working on a very intellectual academic paper describing why the House of Representatives should have acted and had the legal authority to act to name him president. Meanwhile, he didn't really. It was very his followers were very frustrated because they often couldn't get through to him or get him to take a position other than that. Going back to one thing Mr. Goldfeder said, Tilden himself said that if the House had acted, which they I think legally could have done under the precedent of 1824. And if they had just said, well, Tilden is the president, then he said he would have come to Washington and taken office.
Mm-hmm.
And because they didn't, he said he had no standing to do so, and he never wavered from that. But I do agree, Hayes won several elections, and he won very close elections a lot of times because he was a good politician. The one thing I'll say about Tilden, if he had been president, the one thing that occurred to me that there was a huge railroad strike in 1877, and Hayes actually sent federal troops to fire on the striking workers in many states, and especially up north. Tilden, who had worked with many of the railroad interests and was actually an attorney for many of the railroads, I think it's very possible that he could have averted the entire strike, and he certainly wouldn't have sent troops to gun down strikers the way Hayes did. So that's one issue. The last thing I would say about it is the main difference. I agree that Hayes was a better actual politician, but if Tilden had just been seated, he would have had the authority to have been legally elected without all the shenanigans that went on afterwards. So it really didn't do Hayes or the country any good in the long run for Hayes to become president, because he had very little power and very little influence in the 4 years that he was president. So, it's imponderable whether who would have been better. It's hard to say. Mr. Goldfeder is right that legally, that's the laws worked, right? In the sense that those three states in the South did have the legal authority to choose which person won their election. So in that sense, I guess the system worked in that sense.
So I will be the naysayer here in this panel. I think it's difficult to see Tilden and Hayes in isolation. I think it's really important to remember the platforms that they represented, the parties that they represented. Hayes really was the man of the liberal Republicans who had actually joined with Democrats to nominate Horace Greeley in 1872 against Grant. They were back in the Republican Party, but they had taken over the Republican Party. And they were a party of railroad lawyers, of people who were very against the government interfering in anything. But when it came to using the repressive powers of the government to fire on striking workers or to put down indigenous nations in the West, they didn't hesitate to do that. So they were anti-big government only in a certain respect. When it suited their purposes, they would do this. Now, Hayes, I have to, reiterate that even after his election, he goes on a tour to the South and he meets only with elite Southern white conservative Democrats. He basically has nothing to do with Southern Republicans, the majority of whom are African American, and who are coming to him and telling him about the amount of repression that they are facing. So he is a reconciliationist president, but at what cost? And as far as the rule of law goes, there is none in the South at this point. In terms of, a formal putting forth of, election returns, etc., that continues throughout the Jim Crow South, as it does right up to the passage of the Voting Rights Act of 1965 and the Civil Rights Act of 1964, which, mind you, said that they were enforcing the 14th and 15th Amendments to the US Constitution. So I think it's really important to see what both Hayes and Tilden represented. I think Tilden was clearly belonged to a faction of Northern Democrats who was not so sullied in his connection with with this kind of very unregenerate, unreconstructed, racist Southern Democratic faction. He had been a reform governor. He had rooted out corruption. But he was a bit of an elitist. He was a gold bug. It's not clear that he would be a person who would be very sympathetic to striking workers or others, as many other Northern Democrats who represented urban constituencies in the North, urban immigrant constituencies. They were sympathetic to them. It's not clear that Tilden would have been one. He was a reformer. He, was actually rooting out corruption in in Tammany Hall. These were the kinds of things that he was known for. But as president, he would have followed the National Democratic anti-Reconstruction platform. And so for that reason, I think it's sort of choosing between two bad options. Hayes presides over the retreat of Reconstruction, and Tilden would have definitely hurried that process. We see that when Grover Cleveland becomes president. And then eventually, when Woodrow Wilson, the first Southerner after the Civil War, becomes president and introduces segregation into Washington, D.C., fires all Black employees of the federal government, and the KKK marches down the streets of Washington, D.C. So I think it's really important to remember this and to see how it is also connected to the legal retreat. This admiration that we have for our constitutional order and for the rule of law is something that is literally overthrown at this time. And it's important to recognize that. After all, the Chief Justice of the Supreme Court, Edward White from Louisiana, was not just a former Confederate, but he was a member of the White League, of this racist terrorist organization. And then he's the Chief Justice, and he's presiding over many of these cases that mark a retreat from the Reconstruction constitutional amendments and laws. So for me, any Democrat in the 19th century was bad news, even someone like Tilden, who had a reputation as a reformer. As far as the project of creating a genuine democracy in the South and upholding the rule of law and upholding the Reconstruction constitutional amendments, Tilden would probably have been worse than Hayes. But Hayes was bad enough.
Well, just since nobody's defending Tilden at this point, let me just give you one story about him, since I was the one who said he was not very cordial. The one elected position he held before he became governor was an assembly member in New York State. It was earlier years. There was a big uprising in the Hudson Valley, where I live a lot of the time now. It was a manorial system then. So the tenant farmers, for the most part, in both the Livingston and Rensselaer manors, were not enslaved, but there was a kind of serfdom in the Hudson Valley of New York. There was a big uprising of the tenant farmers at one point because the heirs of one Stephen Van Rensselaer, who had been somewhat kind to the tenants and not collected rents, decided after Van Rensselaer died that they wanted to collect the rents. So the tenants rose up, and really it was quite violent in Columbia County. The governor then, Governor Wright, sent Tilden to see if he could work things out. And he did. He came up with a solution that both sides agreed to. And that was that the tenant farmers were to pay their rents, but the rents were really mortgage payments, and that within a few years they would own the land that they were tilling. And it worked out. So he did have that ability to conciliate, at least in his earlier years. I don't know if he could have done that when he was during the railroad strikes. But while he was the railroad lawyer, he rejected both Gould and Fisk's, the two railroad magnates, attempt to get him to be their lawyer permanently. In other words, they both wanted to put him on each on a $10,000 retainer, and he rejected that. He said, no, I will only charge for actual work that I perform for you. I will not take a retainer. So he wouldn't take a side in that way, just to defend Tilden a little bit, since he needs a little bit of defending, I think. Well, my next question was going to be, and I think you almost answered it. In his book, The Centennial Crisis, William Rehnquist wrote about the election of 1876. He wrote about it, and I'll tell you when because it's important. It was in 2005. So it was well after Bush v. Gore. And he said, the Hayes-Tilden election dispute was the most contentious political imbroglio of the last half of the century. Thanks to the Electoral Commission created by Congress and acquiesced in by Hayes and Tilden, the nation avoided serious disturbance or bloodshed and went about its business. The outcome was a testament to the ability of the American system of government to improvise solutions to even the most difficult and important problems. Well, Jerry kind of agreed with that. Would you?
So let me say that he wrote this book, in my view, as an apologia for Bush v. Gore, because the Supreme Court justices were involved in deciding who was president in 1877 during the Electoral Commission, and obviously they played a role in deciding who was the president in the year 2000 in the year 2000, the 2000 election. And so I think he felt, I don't know this, but I think he felt defensive about the role of the Supreme Court in the 2000 election. And when you look at the book, not only does he say what you've just read, but there's a whole section on involvement by Supreme Court justices in a variety of activities that have nothing to do with the court itself. And he gives the example of Chief Justice Warren chairing the what became known as the Warren Commission, as relating to the assassination of President Kennedy and the role in the Nuremberg trial. So I believe that when all is said and done, he wanted to convey the normalcy, if you will, of the Supreme Court justices playing a role in political affairs, because there was such criticism of the Supreme Court's role in the 2000 election. So I think that's why he wrote the book.
Okay, Mr. Morris, would you disagree with Judge Rehnquist?
Yeah, I would I think it's always a problem when you get the courts and the politicians and all to decide who won an election based on what they should count or not count, or who might have voted or who didn't vote or who could have voted. And I certainly, as my own personal point of view, which doesn't count for anything, except I hated the 2000 election interference by the Supreme Court and Judge Rehnquist, and he can defend it, but I disagree that they should have. But I'm not a legal scholar, certainly not the Chief Justice of the Supreme Court.
Thank you. Here I am going to actually agree with my fellow panelists. I think Bush v. Gore was terrible. And it was precisely the kind of judicial activism that many conservatives like Rehnquist had blamed the Warren Court for, which I think is actually not correct because the Warren Court was simply upholding the Reconstruction constitutional amendments, which the court refuses to now implement in many respects. I think the slide began, I'm talking about this historically, not as a legal scholar, but the slide really does begin with Bush v. Gore. And then there are a number of decisions after that. Citizens United, Shelby County versus Holder, which kneecaps the Voting Rights Act of 1965. And now the immunity decision for Trump, the king can do no wrong. We are a republic, not a monarchy. Even so-called official acts of the president are not above the rule of law. And so I really think I look at the present day Supreme Court, it's openly partisan and rather unethical judges with the lowest approval ratings that the Supreme Court has ever gotten. And I compare it to the Supreme Court of the late 19th century, the Supreme Court of Plessy versus Ferguson, Williams versus Mississippi, of the Wong Kim Ark, which was, the one decision that upheld the 14th Amendment's national citizenship, but giving the green light to all these other egregious, unconstitutional actions, both by the southern states and by the federal government itself later on. I see the Supreme Court has not played a very productive role in the advancement of American democracy. And it's really an exception, Brown v. Board of Education, and that brief period when the Supreme Court upholds the Reconstruction era, 100 years later, the Reconstruction era amendments. And today, again, the Supreme Court, I think, is openly partisan, unethical, and so I don't buy Judge Rehnquist's apologia. He was openly partisan. And as far as election commissions goes, his defense of it, the Constitution required that the election be thrown to the House of Representatives, but that was under the control of the Democrats at that point. And at some point, both the Democrats and Republicans agreed to this maneuver of having the electoral commission. And I think part of it is that a lot of Southern Democrats, as Mr. Morris said earlier on, were really interested in reclaiming the South for themselves and completely getting rid of the threat of Black enfranchisement. So they have like the solid South, the one-party rule in the South, which is what they wanted. Northern Democrats are the ones who are really upset about Tilden's loss even more than our Southern Democrats at that point. And so I think the Electoral Commission was something that eventually both sides agreed to. And maybe, in either scenario, Reconstruction was done away with. So Rehnquist's kind of formal defense of these commissions may have something to do with the fact that he was, as Mr. Goldfeder said earlier, trying to explain away his own interference in stopping the vote count in Florida in 2000. And, there are some people who are institutionalists and they want to play, they want to uphold the norms of democracy, of the rule of law. And so you have to give it to Gore that he accepted that decision. And in a way, the one thing that is probably, praiseworthy about Samuel Tilden is that he accepted it. And even later on, when there was an inquiry in 1878, then there was a charge of bribery against him. But it had nothing to do with him. It had more to do, I think, with his underlings. Tilden himself decided to play by the rules, as did Gore, however those rules were constructed and however much it disfavored them. So in that sense, I guess, in an institutional sense, that worked. But clearly Rehnquist knew that not everything was kosher because he clearly felt the need to defend those maneuvers.
Right. Do any of you want to ask other panelists a question.
I would just ask Mr. Goldfeder, some people have argued that the Electoral Commission was unconstitutional on its face. Is there any value to that, or since Congress agreed to it, does that settle it?
Well, in a way, Congress delegated its own authority to the commission, and after the commission voted, Congress approved it. So it was ultimately Congress who made the determination as to who won. So I don't know that it was unconstitutional. It was not necessary to do that, but they chose to not. They chose to kind of allow another body, another entity to do its work for it, rather than stepping up to the plate and making a decision. But but as I say, since they approved it, they fulfilled their constitutional duty of counting the votes on the day that was appointed for when the votes had to be counted and the president and vice president chosen.
Well, I want to thank the three of you. This has been very interesting, and we got a lot of stuff to think about, I think, if we want to look at history. And as one who believes strongly that we can only learn from history, I very much appreciate all of what you've said, and I think have given us a lot to think about. So thank you very much, and thank you so much for your time, all of you.
And thank you for inviting us all.
Exactly. Thank you. Thank all of you. I enjoyed the discussion.